Mr. Speaker, I take note of the continuous tense as we ran away from it in drafting. So I would want to profile a new rendition that would say fees to be charged.
Fees charged by the council.
Fees charged by the council in respect of application, license, or any other service. They take away in relation.
Yes, in relation. I don't see that.
In respect of.
Any further?
In place of, in relation.
Very well, I'll put a question. As many as are in favor of the proposed amendment say aye. Aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, amendment IV.
Mr. Speaker, we surplus to add the following new paragraph. The terms and conditions of service of staff of the council, including appointment, dismissal, remuneration, and retirement benefits. And I so move, Mr. Speaker.
It is for the constitution of the House. Honourable members, yes.
Mr. Speaker, we are doing legislation, clause 83, terms and conditions. And then you want to come and define appointment, dismissal, remuneration, retirement. If you say terms and conditions of employment, it should be enough for the elegance of it. But why are you listening? When you listen and you leave out others, what do we do? Thank you, Chair.
Yes.
Mr. Speaker, I stand to be guided, but I'm trying to recall any act that we passed in which we said the terms and conditions of staff should be the subject of regulations to be brought to this House. I don't remember any act where we have said that the terms and conditions, if you state by regulation the terms and conditions, it means that anytime that the terms and conditions of the workers is to be changed, they have to come back to this House with another regulation to change the terms and conditions. So we cannot have a situation where the conditions of service of workers will be determined by regulations to be brought to this House. Which workers' terms and conditions have been brought to this House for us to approve? It has never happened. So I don't know the basis for a proposal like that.
Article 124.
I think it's a very good proposal. Should make the
Yes, Chairman of the committee.
Speaker.
No, Chairman.
Yeah, after that, very well. Let me take you first.
Speaker, thank you very much. The reason why they seem to be bringing the terms of conditions of staff here is because the school is being established, and under normal circumstances, this should have been contained in the statutes of the school. So if we can draft to make provision for these conditions to be catered for, because we have established the Ghana School of Law, which we are going to appoint some staff to manage. No, by this act too, we do establish by 78 of the new document, we have established the School of Law, the Ghana School of Law, as a directorate. So, but we should find ways and means to put this one we can take the conditions out, I agree. No, I agree we can take the conditions out, but we have to figure out a way to capture it.
Honourable members, can we look at Article 1245, which I would want to read. The Parliamentary Service Board shall, with the prior approval of Parliament, make regulations by constitutional instrument prescribing the terms and conditions of service of the officers and other employees in the parliamentary service, and generally for the effective and efficient administration of the parliamentary service. So this is not novel. Yes.
Mr. Speaker, you cannot elevate the mechanism for the determination of a council established by an act of parliament to the status of a constitutional body, a coordinate branch of government. That's what you are seeking to do. Because you see, when the Constitution establishes the parliamentary service, you want to take it out? Good.
Yes. What is the position?
That they want to take it out. It should be ignored. So you are standing down the amendment.
Yes.
Yeah, Mr. Speaker, may I humbly drop the amendment?
Very well. Amendment.
So moved.
You see, if you even look at the Securities and Intelligence Act that we have just passed, this provision is part of it. The Securities and Intelligence Act. Is also part of it. So I just use the constitutional provisions to demonstrate that if the Constitution can empower the Parliamentary Service Board to make regulation and come out with a condition of service of staff, then we may not be wrong also making law tasking the council to also make regulation on terms and conditions of service. This is not to equate it to a constitutional body. And there are other legislations that we have passed that this particular provision well featured. A good example is the Security and Intelligence Bill that has just been passed. It's also in it. But if you want to abandon it, I have no physician.
Speaker, I'm also getting convinced by the fact that the minister shall, on the advice of the council, so that same council that is advising the minister is going to determine the conditions of service of the council. This is where I tend to agree with Leader that we can conveniently drop it.
This is a condition of service of staff of the council.
Staff of the council.
No, sit down, we have. Mr. Speaker, with your indulgence, let me persuade the majority leader to abandon his objection, citing the reference to parliamentary service. If you take the kind of staff that will work for legal education, you are looking at their terms and conditions of employment, and it's important that provision is made for it in a regulation pursuant to Article 11 of the Constitution. So you shouldn't be insisting that because it's not a co-equal organ of state, conditions of service for public servants is conditions of service for public servants. What we want, and Mr. Speaker, I use, for instance, the parliamentary service. It is through these regulations that Parliament caters for the needs of the staff of the parliamentary service. So it means that the Legal Education Reform Bill is making room for persons employed to work within the general ambit of the General Legal Council. So if you would abandon it, but the chairman should abandon defining retirement, remuneration. Terms and conditions of employment is defined. It may include other variables that for his purpose is not elaborating here. Thank you, Mr. Speaker.
Yes, Chairman of the committee.
Yeah. Speaker, whether we abandon this or not, it is implied under 83 that they can still perform that function anyway. And so I think it was just for purposes of emphasis. It is the minister shall, on the directive advice of the council by legislative instrument, make regulations for the effective and efficient implementation of the act. They can still come under this general clause. So,
Yes.
Mr. Speaker, once you are admitting that it will still be by regulations, then we might as well just continue with what we are doing. Because it is still going to be done by regulations. Speaker has tried to draw attention that there are precedents where we have used regulations. I just feel that to determine conditions of service via regulations means that at all times, if there's going to be a variation, you have to come back to Parliament for the variation. I thought that this would be quite a tedious, exercise. It might not even work in the favor of the workers. That each time that their conditions of service are going to be varied, then you'll have to go to Parliament, pass regulations before you can vary it. So I thought that there should be other ways of determining conditions of service instead of passing regulations. But I abandoned my objection, and we can pass it.
Mr. Speaker, on the basis of that, I want to go back to the student who cancelled his answer script, and when time was against him, he said cancellation, not cancelled. Mr. Speaker, I abandoned the fact that I want us to maintain IV.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. No, yes, the chairman's amendment. So I will now put a question. Now I'll have to put a question on entire 83 in the absence of any further amendment. Yes.
Mr. Speaker, I've seen in subclause 3 in the Gazette and on the website of the council. So that means on the website you want electronic, and then will the Gazette serve the other purposes? That's in 83, if I'm holding the correct bill. On the website of the council, there may be a rural person who has no access to a website. Are we assuming that the person will get it in the Gazette? Let me see.
So what is your proposal?
Beyond electronic, Mr. Speaker, unless I'm not, legal education bill 833.
So what is the proposed amendment? Very well. So I can put a question on entire clause 83. As many as are in favor say aye. Those against say no. The ayes have it. Clause 83 is ordered to stand part of the bill. 84.
Interpretation.
Speaker, 84 amendment proposed add the following new definition. Director General means the Director General of the Legal Education appointed under Section 11. I so move.
It is for the consideration of the House. I'll put a question. As many as are in favor say aye. Yes.
Thank you, Mr. Speaker. Now, if you look at the interpretations, it says the council means the Council for Legal Education and Training, for which there's going to be a Director General. So is he the Director General? Are we going to keep it a Director General of Legal Education only, or Director General of Legal Education and Training? So So my proposal is to add "and training" instead of leaving it as the Director General of Legal Education. And training, yes.
It is for the consideration of the House. Yes, Chairman of the committee. Chairman of the committee. What's your view about the proposed amendment?
The proposal, I think the chairman was not with us. So the proposal is that you move for an amendment of the interpretation clause to add Director General, and then for Director General to mean the Director General of Legal Education. And he is saying that throughout the bill, we've been talking about legal education and training. So you should add legal education and training.
Mr. Speaker, I think I'm in line with that.
Very well. So the new rendition will be Director General means the Director General of Legal Education and Training appointed under Section 11. Yes.
Mr. Speaker, for the avoidance of doubts, the last time we were at this stage, I recall that Honorable Kabiru had made this proposal and it was carried. So I don't know how come it's not reflecting, in the proposed amendments. I think it was carried right here in this hallowed chamber. So let the records.
It was a good observation that he brought. So you are in agreement with him. Are you in agreement with him, or you disagree with the proposal?
I want it to be put on record that this particular proposal had been proposed by Honorable Kabiru and carried here.
So if it is consequential,
exactly.
If it is consequential,
exactly,
and it is consequentially being carried, so the proposed amendment by Dr. Che is correct.
It's correct.
Is that not so?
But it has been done before.
And that is what we are putting the question on.
Very well.
Yes.
Mr. Speaker, first and foremost, we didn't get the sense that the proposed amendment proposed by Dr. Che was consequential to the amendment that was carried in the previous consideration of the bill. So that is the point that he wanted to establish, that we had proposed an amendment to the Director General for Legal Education by the addition of legal training, by the addition of education. So he is proposing that consequent to that amendment, we are having a consequential amendment to the interpretation by the addition of education. So that was the direction I thought you ought to have given us. But if it is carried as if it is a substantive amendment, that was the confusion we wanted to clarify with the intervention he made, Mr. Speaker.
I don't know where the problem is coming from. If there has been an amendment, there is a further amendment which was not in consonance with the earlier one, and the honorable member is rightly drawing attention to it. Which position is correct and has been agreed upon? What else will I do apart from putting the question?
Mr. Speaker.
Because the previous one was standing in your name. He is the one now drawing the attention that previously this was what happened. So I'll have to put a question on the amendment that he's proposing.
Mr. Speaker, no, I agree with, but I'm just saying that you have directed before this House that consequentially we should effect the amendment. So even if that direction was to be carried out, this proposed amendment would have been moot. That's the point we are just trying to, because you had directed that.
No.
You had directed that.
No. You see, this is a fresh amendment being proposed by the chairman of the committee, and he is making a further proposal to the chairman's proposed amendment. Yes.
Mr. Speaker, I'm sure the honorable member for Wale once Hansard to recognize him, that his royalties for participating in the consideration stage of this bill is that when the chairman moved the amendment, there was a further amendment by the Honorable Che, but in the original thought of the member for Wale Wale, Mr. Speaker, you can do this for him for the purpose of that this proposed amendment, even though moved by the chairman, had the support of the Honorable Che and Honorable Kabir, and then you put the question for the record.
Yes.
So he can go home and say
that is what
in
exactly I want
considering
to
this
do.
bill, he was heard. Thank you.
As many as are in favor of the proposed amendment, further, yes.
Speaker, I know Honorable Harun Idrisu just made the statement on a lighter note. But Mr. Speaker, Hansard will record the printed language. So it is important that the matter is clarified. Mr. Speaker, the contention of the respected member of Wale Wale is to the effect that he is the originator of the said amendment. Bona fides are bona fides, and it must be respected as such. So it's not a matter of that he wants Hansard to capture him as having merely participated. No, Mr. Speaker, we know the industry of Dr. Kabiru in this house. No, it's a matter of fact. The records will bear him out. We know his industry, a first timer who participates in legislation. He argues well on matters. So, Mr. Speaker, it's not just for the sake of being recorded by Hansard. And I don't want, Mr. Speaker, what is factual is factual. Kabiru is a first timer. We know what he does. We should give to Kabiru what belongs to him. Mr. Speaker, so he is the originator of the said amendment. We acknowledge that chairman of the committee is taking it up, but his contention is that same must be so recognized. Mr. Speaker, that is all about it. Mr. Speaker, that's all about it.
Would I ask Dr. Che to drop the amendment and let it be moved by Dr. Kabiru?
Mr. Speaker,
because it comes to the same thing.
Mr. Speaker, it was a joint. Mr. Speaker, it was a joint proposal. They worked together, Mr. Speaker. They worked together. Dr. Che and his colleague Kabiru. Mr. Speaker, in the minority caucus, we work as a team. We work as a team. It's a teamwork. We don't work in silos and we don't look for personal glories. We work as a team. So, Mr. Speaker,
minority leader, what do I do apart from putting the question?
Mr. Speaker, I am only putting across a point, but you can put the question. Mr. Speaker, you can put the question. You can put the question. Say that they've worked together to achieve this, and we all know that in this legislation, even where the majority could not marshal its members, we've had these two as constant. Mr. Speaker, there's always a way to get the majority chief whip on his feet. Mr. Speaker, I mean, if he's not comfortable with it, same is he should let it slide. He should let it. Very well. You should let it slide. You are my classmate. Very well. Let it slide. Oh, what do you mean? Let it slide. Let it slide. Majority leader, if you want to be on your feet, you have other serious matters. Mr. Speaker, the majority leader knows that he has other serious matters that will require cooperation. I say let it slide. That's okay. Let it slide. If he wants to pursue it, he should pursue it at his own peril.
Yes.
Mr. Speaker, this one won't slide. It won't slide.
Mr. Speaker, put the question.
Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. the proposed amendment by the chairman of the committee, further amended by Honorable Dr. Che, based on consequential amendment proposed by Dr. Kabiru, is ordered to stand part of the bill. Yes. Chairman, VI.
Mr. Speaker, VI add the following new definition. General Legal Counsel means a council established under Section 1 of the Legal Profession Act, 1960, Act 32. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is, those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, VII.
Mr. Speaker, the third amendment under Clause 84 add the following new definition. Law program means a Bachelor of Laws degree and law practice training. I so move.
Honourable members, it is for your consideration. Any further amendment? Yes.
Or any other, Speaker, we need to further expand it to include or any other accredited program. Because, Speaker, the intention is that some of the faculties or law schools may introduce diploma programs in the near future. So, or any other accredited program in defining a law program. Don't limit it to LLB and the professional program or any other accredited program. I think that should be included in the definition.
What do you envisage to be any other accredited program?
Under this legislation, we have established the Ghana School of Law to offer, in fact, post-law programs. It is not an LLB program, and it is not the licensure, the professional training program that will lead to the licensure. It's a post-call, but it's accredited. So, good. Yes.
Mr. Speaker, I want to propose a further amendment by the deletion of means and substituting with includes. Law program includes a Bachelor of Laws degree and law practice training.
Majority Leader.
Mr. Speaker, we are defining a term consistently used in the bill. And consistently, 2 law programs have been in contemplation. The first is the degree which qualifies you to embark on the second, which ends up with a practicing law training program. So that is what consistently we have intended to express in the bill. So when we are defining, it is that which we are defining, not in future what might happen, not what might happen in future. So because we are defining an expression used in the bill, and at all times in considering this bill, I've only heard Bachelor of Laws degree and then, law training, law practice training. So that's we should limit it to that. No, there's no mention of a diploma anywhere. There are provisions about post-call program, but even the post-call program is not a diploma. It's just to prepare you to write the courses that they think you should write in order to be called to the bar or to be permitted to practice within the jurisdiction, because you've already been called to the bar in some other jurisdiction. So let's limit it to the 2 terms, which is Bachelor of Laws degree and then also the law practice training.
Speaker, for the first time, I will disagree with my boss. Speaker, yesterday we adopted new clauses for the establishment of the Ghana School of Law. And Speaker, as part of the functions of the Ghana School of Law, we are saying that the Ghana School of Law shall A, administer the post-call law course. Yes. Yeah, the post-call law course. And that's a law program. It is. It's a law program. And we have established who and who will be eligible to participate in the post-call law program, or law course, I should say. So once we are defining what constitutes a law program, we should advert our minds to these special areas of training, to include them. We may not be specifically mentioning them, but once you introduce includes, these are accredited. These are courses that are accredited, and will be run by one of the institutions that we are establishing under this act. So if my boss can, if leader can avert his mind to that, then it will serve the purpose. They wouldn't have to specifically define. Yes, that's why I'm saying that. I think he got up about the inclusion just to say that it should be exclusively referred to the LLB and then the professional training. But I'm just trying to draw his attention to the fact that once we are establishing the Ghana School of Law to run courses like this, I am even of the view that this house...
All the issues that you are raising,
yes,
the answer is in clause 74 of the new bill. And if I may read, qualification for enrollment. A person qualifies to be enrolled on the roll of lawyers if the person A obtained a Bachelor of Laws degrees from a university accredited by the council. B, hold a law practice training certificate. And C, passes the National Bar examination. 2, despite subsection 1, the council may recommend the enrollment of a person who qualifies to practice law in a country with a system of law analogous to that of Ghana, which has a reciprocal arrangement with Ghana. B, has successfully completed the post-call law course conducted by the Ghana School of Law and passes the bar examination. So that one is something that the council may recommend. But for the purposes of this act, if you are talking about a law program, you are talking about the Bachelor of Laws and the professional practice training. That one may come by way of a recommendation by the council in line with 74(2).
Speaker, my difficulty is that how do you categorize what is to be done by the Ghana School of Law? How is that categorized? Is that an apprenticeship? Because the post-call, they write exams. It is not just tuition. They actually go through, it used to be 6 months, now they do a 1-year tuition program, well structured with a curriculum, and they write examination. When you pass the post-call, then you are recommended. Now, if you limit the definition of a law program to these two, tomorrow I can challenge the fact that what the Ghana School of Law is doing is not a law program. So it cannot constitute a basis for the council to make any recommendations. So you support me. Okay, then so all I'm saying is that if you look at, okay.
I think that the problem is being more serious than we are debating. Because all this while, I've been scanning through the bill to see where law program is used. I don't know if the chairman has been able to identify any specific mention, any clause that says law program. Because it is consistently law degree program or the law practice training. There is no mention of law program that you are trying to define. Where? Which clause?
Now, go to clause 3B.
3B.
Yes. Clause 3B.
3B. I'm holding the old copy. In collaboration with the Ghana Tertiary Education Commission, set the standards for the accreditation of universities. Which other clause?
There is a proposed amendment to it to
What does
delete
the amendment
university
say?
and then put in place law program.
Oh, okay. So that okay. That's why you are defining it, because I'm
Yes.
holding the old copy.
Oh, because if Speaker,
Yes, you have the floor.
Speaker, if you look at 52 grading standards, a university that runs a law program. After that, if you come to 3, a university that runs a law program, there are a lot of them.
Yes, it's been used several.
52, 53, 54, 55, 56, a lot of them, leader. So we may have to really define it.
Yes.
Mr. Speaker, rightly so. So all the subsequent ones that we find in other clauses are all premised from the amendment that we made under 3B. Under 3B. Yeah.
So clearly, the program is Bachelor of Laws and then the law practice training. However, the 74(2) is giving room to the council where such recognition is made. It is then that the post-call will kick in. So far as this legislation is concerned, it's talking about the Bachelor of Laws and the professional practice training. Yes, let me hear you, Honorable Fifth.
And Mr. Speaker, looking at even the post-call courses, which my Honorable Chief Whip is trying to say we define or add to the definition, those courses are courses that are found either in the LLB or the law practice. So it is part of the legal education courses. So it falls within the LLB or that of the practice one.
Yes.
Mr. Speaker, the programs that we envisage the Ghana School of Law has established to run include the post-call. The post-call has its special curriculum with examinations. Yes, the courses, they are running those courses because you are supposedly qualified in a jurisdiction outside, that is with a legal system that is analogous to the our legal system, but you haven't undertaken those courses, so you can fail. That is a law program. No, they are not. They are not. So I'm saying that once we seek to define, we should enlarge it enough to accommodate those general courses.
Honorable Chief Whip.
Speaker, if I may land.
Yes.
Because you are saying that for the purposes of this act,
Yes.
and for the purposes of this act is the one establishing what the Ghana School of Law should do and giving it functions. So we must be careful how we limit, how we define courses. Otherwise, tomorrow we'll run into problems. So the includes gives latitude. Once you say includes, it gives latitude.
Honorable AG, what do you want to be the definition of a law program? Should a law program in the context of this bill be defined to include the post-call?
Yes, Mr. Speaker. The reason is simply that if you don't define it to include the post-call, then it means that the post-call will fall outside the statutory framework of this bill. So I think the Chief Whip is right. And as he explained, the post-call law course is meant for those who are qualified in foreign jurisdictions and want to become lawyers in Ghana. So it's a program, and it is one where they study the basic foundational laws of Ghana. So constitutional law, our land law, family law, customary law, as well as our legal systems.
Post-call, will they also write the bar exams?
They will write a bar exam after they have, passed the post-call. When they have taken the post-call program and passed, then they qualify to write our national bar exam. They are not automatically, admitted to the bar. Yes.
They will write the exam.
Well, I'm not getting it like that. Flowing from 74, AG 74.2 is saying that despite subsection 1, the council may recommend the enrollment of person who qualifies to practice law in a country with a system of law analogous to that of Ghana, which has a reciprocal arrangement with Ghana. Then 2, has successfully completed the post-call law course conducted by the Ghana School of Law and passed the national bar exams. So what should be the correct rendition for the definition of a law program?
Mr. Speaker, we substitute means with includes.
Then I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, Chairman, VIII.
Speaker, VIII add the following new definition. Law dean means a person responsible for a law program of a university. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, IX.
Speaker, IX amendment proposed. Insert the following new definition. After the definition of tribunal, university means a tertiary education institution. I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, any further proposal? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 84. As many as are in favor say aye. Those against say no. The ayes have it. Clause 84 is ordered to stand part of the bill. Clause 85.
Revocation.
No advertised amendments.
It is for the consideration of the House. Any proposed amendment to Clause 85? In the absence of any proposed amendment, I'll put a question. As many as are in favor, say aye. Those against, say no. The ayes have it. Clause 85 is ordered to stand part of the bill. Clause 86.
Consequential amendments.
Speaker, Clause 86, amendment proposed, delete and insert the following as advertised on page 8. I so move, Mr. Speaker.
It is for the consideration of the House. All members, any further amendment? I'll put a question. As many as are in favor, say aye. Those against, say no. The ayes have it. The proposed amendment to Clause 86 is ordered to stand part of the bill. Now to Clause 86. Those in favor, say aye. Those against, say no. Clause 86 is ordered to stand part of the bill. Clause 87.
Savings.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. In the absence of any further amendment, I will put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 87 is ordered to stand part of the bill. Clause 88.
Transitional provision.
Chairman of the committee.
Speaker, Clause 88, amendment proposed, delete and insert the following as captured on page 8 and 9. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 88. The proposed amendment is ordered to stand part of the bill. Chairman, XII.
Speaker, XII under Clause 88, amendment proposed, add the following new subclause. Speaker, as captured on page 9. I so move.
It is for the consideration of the House. Honourable members, any further amendment? I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. Yes.
Speaker, just
Yes.
the XII, just for our own elucidation, if you look at the last line, okay, if you read it, a student enrolled in a professional legal training program before coming into force of this act shall continue under the existing regime. Mr. Speaker, just for your guidance, so which one would be the existing regime? The new law that would have been made, or the one that would have been repealed? Just for clarity, Mr. Speaker.
Well, I do not see any ambiguity by chairman of the committee. This is talking about a transitional provision. So, those in the law school now, the system that applies for them to become a lawyer will continue to apply to them. Probably the understanding is that they will not be writing the bar exams. But the students that are going to be employed under this act, they will be writing the bar exams. That's why the savings and then the provision is saying that whatever is the existing regime will be applicable to the existing students.
Speaker, rightly so. Because the contemplation of this bill, it's for those who are currently not at the present law school. And so for LLB students who are, yes. Yeah, because the law is not passed yet. So there's an existing law school. Yes. It's very cool.
You see, honourable members, the issue is whether the law that you are passing now will take retrospective effect to affect the continuing students. So the answer is no. Therefore, those students will be under the existing program because this law is not in effect yet.
Speaker,
I think that we can make it clearer because you see, once this old law, once this is passed, that old law will not be called an existing regime. The old law, we cannot refer to the old law as an existing regime. Existing regime will be the new law. Speaker, we just have to make sure that it is clear enough, because if we are even disagreeing about this here, you can imagine the confusion that will be out there. So let's just make it clearer. Existing regime. By the time this law will be enforced. Yeah, if you say the law that was enforced before the coming into force of this the act, that's clearer. But if you say the existing regime, which existing regime would that be? Because if the person drafting this was thinking about what is going to be a repeat law, you understand? And example, I'm not a lawyer, so some don't be.
Mr. Speaker.
Yes.
The essence of this house is to deal with some reforms within the existing regime. And as soon as assent is given to this law, it becomes effective. It becomes effective. So the transitional provisions must be in respect of arrangements that to protect the interests of the current students in the system and the future or the prospective students. Please. So the laws, the standard of legislating in this house is that if you want to save provisions from an existing enactment and make it effective in the new law, we do so they become applicable as part of the new law. Otherwise, the new regime will be the effect of this law. And Mr. Speaker, when we speak of the law school, we are no longer speaking of LLB holders. We are saying that the law schools will run LLB program with proper curriculum defined under this act or program under this act, and then the professional training stage. So are we going to say that, for instance, those who are in level 100 now, in my alma mater, Faculty of Law, University of Ghana Law School, though for the next 6 years or for the next 5 years, there will be a certain regime that will govern their training and a certain regime that will govern the training of those who will become immediately after them. So there will be a huge confusion. So the transitional provision, we must avert our mind to the fact that where there are provisions in the existing law that we think should be applicable to situations going forward, we save those to make them part of the new law. That's all we do. So it cannot be that we are saying that an existing regime, it should be the law in force. It should be the law in force. So the language the drafters, is a standard provision that we adopt in all the legislation. So they should look at how we couch it in other provisions in terms of the transitional, or in terms of the transition. But Speaker, finally, this law, our intention is to make it effective immediately, so that the law schools will take immediate steps to put their house in order in compliance with this law in training our students. There will be a huge disappointment if they hear that the law we have enacted will be applicable to those who are in SS and are yet to enter. Exactly. You are saying no, now you are waking up to the reality. So that is not the intent of this house. It should be effective immediately.
Well, so let's look at it this way. So students in professional part 1 who have written their exam, the professional part 1 exam, they are now in professional part 2, writing to be called to the bar. Are we going to stop them to say that they must also write the bar exams before they are called to the bar?
Speaker, no. That is why the provision in the existing law that will make that possible, we save those provisions.
Yes.
And make
So
it part
if you
of
are
this
saying
law.
that
Yes.
this law,
Yes.
when passed, it must
Yes.
take immediate effect.
Yes.
That's where I have.
Speaker, it will take immediate effect. The effect of transitional provision is to save clauses and sections of existing law and make it
Yes.
exactly.
Yes. Right. That has been accrued.
Yes.
Yes. Because for those students, their right has already accrued.
Exactly.
So all that the provision is seeking to do is to exempt them from the application of this law.
Exactly. Exactly. But the LLB holders, that will be prospective, Mr. Speaker.
Yes.
But those who are at the LLB level now are expecting that they'll write the final bar exam. You know, and they will not be writing and then they will not be subjected to a certain entrance exam. And as a result of which they are sieved.
Yeah, as for that one, I think we are on the same page.
Okay.
Because some people have written the entrance exam already.
Yes.
And they are already at the law school.
I agree with you.
You understand? So those are the people whose rights have accrued.
Yes.
So in order not to subject them to the new law, and in order for the new law not to take retrospective effect, there is the need for this particular provision to serve their rights.
Speaker, but the definition of the law school under this law is no longer co-terminus to the Ghana School of Law or Ghana School of Law. It enlarges to the law schools as we know it, the faculties as we know it.
Mr. Speaker.
Yes, leader, maybe let me hear them before I come to you. Yeah, Honorable, you know.
Thank you, Mr. Speaker. Mr. Speaker, I think what my colleague is saying is the use of the word existing law instead of applicable at the time, which you could see that in the earlier provision, it made use of, if I may read, Mr. Speaker, a person, 93, a person who before coming into force of this act is enrolled at the Ghana School of Law, concluding, it says that the law course under the applicable enactment and curriculum in force at the time of enrollment. That is so clear. But this one, it says existing law, and the colleague is saying that if we pass this law, this...
It didn't say existing law.
Existing regime.
Yes.
And I'm saying that if we pass this law would now become the existing regime. So
you see, before this law is bringing out a different arrangement altogether. You understand? Before these arrangements will come into place, there is an existing regime where a person can become a lawyer. There is a regime in existence before this law. So they are saying that the students who are there before the coming into force of this law, they must go by the existing regime. Yes, Honorable Patrick Yawoma.
Mr. Speaker, I think we can look at it this way, from this rendition. A student enrolled in a professional legal training program before the coming into force of this act shall continue prior to the coming into force of this law. But that's all.
So continue how? That will be the lacuna. Let me hear Baba Jaman.
Yes, Mr. Speaker,
Yes.
I also, if you ask a simple question that if this law is passed today, does it take immediate effect? If yes, is it what becomes the existing regime? That will be the question that we need to answer. So if the new law is going to be the existing regime, then we need to look at the rendition here, because they are saying that a student enrolled in a professional legal training program before the coming into force of the act shall continue under the existing regime. Somebody will interpret that to mean that the law in force. So it can be either we say, if you say existing regime or the act shall continue under the then existing regime or the applicable regime at the point of enrollment. So we need to clarify that, because otherwise I may interpret it that the existing regime is the act that is in force.
Maybe we have to qualify it by saying the existing regime before the coming into force of this law.
Exactly.
Yes. Let me hear majority leader, then the AG and the chairman will finish it out.
Mr. Speaker.
Yes.
The amendment proposed that I see advertised says 88, that's transitional provisions, clause 88, subclause 1. A person who before the coming into force of this act, is enrolled Have we taken XI? I didn't. Have we taken XII? We've taken XII.
XII is under reference.
But I think the chairman has an issue with XI. No, the chairman has an issue with XI. He has an issue with XI.
Chairman, I put a question on the XI. We are now talking about XII, which is the amendment under reference. Yes, Honorable John Dako.
Speaker, leader, if you may, maybe if I can explain what has happened to you.
Just propose.
So
Honorable Chairman of the committee, what is the situation?
Mr. Speaker, we're on XII now, but I will crave your indulgence. An XII, we're looking at the word existing regime. Mr. Speaker, I want us to tweak the amendment a little bit to read: a student enrolled in a professional legal training program before the coming into force of this act shall continue under the regime prior to the coming into force of this act. We delete the existing. We delete existing.
Honourable members, I'll put a question.
Yeah. Oh, it's yours.
Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill.
Yeah.
Yes, Chairman of the committee.
Mr. Speaker, while we had traversed XI, I crave your indulgence to take us back to XI2.
Please do.
Mr. Speaker, let me start with XI 1. A person who, before the coming into force of this act, is enrolled at the Ghana School of Law and is undertaking the professional law course shall complete the professional law course under the applicable enactment and curriculum in force at the time of enrollment. These were all in agreement. But 2 now says, a person who completes the professional law course under subsection 1 is eligible to apply to sit a national bar exam. That cannot be. Whoever finds himself in Makola now, whether professional 1 or 2, must go with the old curriculum. You cannot be asked to go back and write the law, the national bar examination. So I propose that we delete 2. The person has accrued rights.
It's a good proposal.
Yes.
Yes. Honorable Patrick Yaboma.
I agree.
Yeah.
I don't ask.
Okay, that's
Mr. Speaker, government can also decide to give this new act some space to take effect. Government can decide that, look, this act will take place or will take effect in next year or 2 years to take care of what Honorable Shaibu's apprehensions are. Because you see, Mr. Speaker, if we allow this provision to be deleted, what will happen to those who would have taken the bar exams, the part 1 exams under 1? Those rights would have been accrued, number 1. Number 2, you are saying that those under subclause 2 will not be eligible to apply to sit in the ensuing exams. That cannot be, because you'll be denying them. They would have started the program already. The program is not only for part 1 and part 2. It's a total program. Once you enroll, you have a legitimate expectation to sit for that exams. Attorney General, once you are enrolled, you have that legitimate expectation to sit for the exams. So it cannot be that I've sat in part 1 and I cannot be given that right to sit the national bar exam when I get to part 2 because there's a new law in force. You'll be denying me. You have to look at that carefully.
Honorable Baba Jamal.
You see, if you seek to delete that completely, it means that if somebody who studied under the old regime and happens to fail, you are closing the door for him to progress under the new regime. So if the person writes the old regime and fails and thinks that he is competent enough to go under the new act, he should be given the opportunity to do so. So if the person studies under the old law, he can be eligible to write the bar exams under the new act. So I think that we shouldn't delete that too completely. We should allow it there so that when a person fails the first one, he can decide to go under the second law and then write it under the second law. I think we should allow it.
Yes, but if you complete the professional law course, like what is here, a person who completes the professional law course under section 1, how on earth will you complete a professional law course and again be eligible under the existing regime to write the bar exams? Because once you complete the professional law course, upon passing, you will be called to the bar.
No, Mr. Speaker. People complete the training all right and fail.
No, but if you fail, that doesn't mean you have completed.
Yes, that's it. You see, you complete.
No.
Mr.
It's
Speaker.
not. It's completion here does not mean passing through. You have satisfied the requirement.
Mr. Speaker,
Then
maybe
you have
the
complete.
interpretation of completing, because completing means that you would have completed and passed and called to the bar.
So let me ask you a question. A student of senior high school who did not write the SS examination, can he claim to have completed senior high school?
Oh, so Mr. Speaker, if he, at the end of the 3 years, they are going to write the exam, and then he fell sick and he's not able to go and write.
So you have completed.
He would have finished. He would have finished the course. But has not
You
been
didn't satisfy the requirement.
No. Anyway,
yes.
my point, Mr. Speaker, my point is that we should fine-tune that too, to allow people who might have failed under the old regime to have the opportunity to write in the next regime. That's my point. Otherwise, you close the door completely to those who might have failed and could not go here.
Yes.
I think I'm of the view espoused by the speaker that if you have completed, you are entitled to be called to the bar. But I also understand what we are trying to cure. So maybe some rendition that addresses that, which is basically to say that if you have gone through the professional law course and you are not successful in the examination, room should be created for you to be eligible to write the national bar exam. Given that you have already gone through the law programs, and the new regime makes provision for those who have gone through the law programs to write the national bar examination. So if you go through the law program also under the old regime, but you fail to pass the examination, you should be among those eligible to also write the bar examination. We as a parliament can confer that privilege. We can confer that privilege on those that have gone through the law program but have failed at the end of the program. But then, because they've gone through the program, they can prepare and write the national bar examination. I think that is the proposal. That's what
is that before AG comes in, Speaker, the current arrangement is that you join, for instance, University of Ghana School of Law for your LLB. You progress to the professional stage. You go through the training, write all the set exams, and you are prepared for the national bar exams. Now, in respect of what Leader is saying, if you are a product of Makola, it means you must apply to Makola for them to submit you or present you to the National Bar Council for the exams when this comes into effect. So there's no lacuna at all. Wherever you train, you have to go back to your school to apply to be presented to write the National Bar exams.
AG, let's hear from you finally on this issue.
Mr. Speaker, I think the confusion arises from conflating the national bar, the professional law course with the law practice course. Because the law practice course under the new regime is the stepping stone to writing the national bar exam. And remember that we provided that you must be issued with a certificate from the accredited law school where you did your law practice course, right? So if somebody currently doing the professional law course after the enactment of the law is doing the professional law course, and as you said, the person merely passed through but did not qualify to write the bar exam, and this regime comes into effect, then that means that they will have to register and write the law practice course and qualify, because that is a stepping stone to the bar examination. They cannot be allowed automatically to write just because they have passed through.
Yeah, but Mr. Speaker, the rendition it doesn't capture the spirit of the policy. So we need. Yes.
Patrick Guama.
Yeah, to add to what the AG said, Mr. Speaker, the AG is mandated to come with some regulations to give effect to some of these issues that we are talking about. And he agrees with me that those issues that we are not finding solutions to, especially with the law practice course and the bar exams, he is supposed to come with some regulations to give effect to some of these challenges that we are seeing. And that resolves the problem, Mr. Speaker. And he agrees with that. AG, your regulations will resolve.
You see, honourable members, what is the existing regime? At the law school, if you fail one paper, you will do a receipt. But if you fail 2 papers, then you must repeat the year. That's the arrangement in place now. So you can say that based on the arrangement that is put in place, you cannot say you have completed the law school without passing the exam. You are either reciting or you are repeating the entire year. So the understanding of completion of the program here means that you are successful. That is what it means. So that's why I'm asking a question. How do you complete this program yet you have a problem being called to the bar? I am saying so because of the arrangement that is being put in place. You won't complete and be called to the bar until you satisfy the requirement. So you are either repeating the year or you are writing arrears.
But Speaker, I'm sure after the coming into effect of this law, the second-year students,
yes,
who will fail a paper or 2,
yes,
will not be able to write or recite the paper.
Well, they should be able to.
And under what regime?
For instance, the transitional provision that we are putting in place says that those who are already in the law school now, they must go through the existing regime. So if the existing regime has a provision for you repeating or reciting one paper, the arrangement must go with you. Yes, this is possible. It is possible. So, honourable members, do we delete the provision or we allow it to stay? In the meantime, to continue the argument, permit me to acknowledge the presence of some revered guests in our midst. First on the list is Reverend Father Andrews Campbell, head of Weja Leprosarium, and 5 cured lepers and staff of the Weja Leprosarium are in our midst. We also have a YIM MA Junior High School, led by Francis Walanyo Anku, head teacher. They are from Equiapim South, they numbered 66. Then we have Sure Success College, led by Francis K.M. Alowodo is the director. They are from Ewutu Senya East, they numbered 75. Then we have Jukwas Senior High Technical School, led by Francis Atta, a teacher. They are from Hima Lower Dentra. They numbered 64. Then we have Father Andrews, we have announced him already. Then we also have Local Council of Churches, Papasi area, led by Reverend John Kosa York. General Secretary, they are from Ewutu Senya West, they numbered 18. Honourable members, on your behalf, I welcome all of them to Parliament of Ghana and urge them to have a very fruitful visit. Yes.
Speaker, this is just a special prayer, just to, apart from acknowledging Father Campbell. Speaker, tomorrow he's going to be 80 years. And he's an Irish missionary born. He's been in Ghana for about 50 years. He's the head of the Leprous Aid Committee. He's the head of the Weja Leprosarium. He's from my constituency. And he served well. So, Speaker, I thought that I should take the opportunity to wish him a happy birthday. And yes. Wherever he votes is not the matter. I love him because he's Father Campbell and he served well, Speaker. Yes. Thank you very much for this opportunity.
Honorable Jerry Ahmed, is that all? You have to organize his birthday and invite us to attend.
Speaker, I will engage. Speaker, I will engage.
Yes.
Yeah, Mr. Speaker, I just want to make a correction. Honorable Ahmed described Father Campbell as an Irish. But, Mr. Speaker, to the best of my knowledge, Father Campbell is a Ghanaian. He's a Ghanaian. And so we need to correct the records. And
so the two of you,
that he's a Ghanaian of Irish origin.
So the two of you must come together and do the needful for us to enjoy with him. We are most grateful for you coming to visit us in Parliament. Yes?
Mr. Speaker, on that auspicious note of wishing a very distinguished person a happy birthday tomorrow. Yes, I think let me also join my colleagues to great works he's done for this nation. And we pray for longer life for him. And may Allah take him to the next step. On that note, may we get back to 88.2. Speaker, while I appreciate the fact that when a person completes the law course under subsection 1, it is moot to say that he is eligible to apply to sit the National Bar exam. But I appreciate the import of what that clause was trying to envisage. And so I propose we delete it and let it find expression in the regulations. So 88 to be deleted. I so move, Mr. Speaker.
All members, I'll put a question. As many as are in favor, say aye. Those against, say no. All members, the ayes have it. The 88 to is accordingly deleted. Yes.
Speaker, with respect, if you can grant me leave for us to go back briefly on 74, with your leave, Speaker.
Very well. Let's deal with this amendment before we can do that.
Okay, all right.
Yes. Having looked at 88.1 and then the proposed new clause in XII, Chairman, what is the difference? And then the proposed amendment in XII.
But it's a bit of a difference. Speaker, a student enrolled in a professional legal training program before the coming into force of this act shall continue under
the existing regime. That's correct.
No, under the regime prior to the coming into force of this act. We did some amendments.
And then 88.1 is saying that a person who before coming into force of this act is enrolled at the Ghana School of Law and is undertaking the professional law course shall complete the professional law course under the applicable enactment and curriculum in force at the time of enrollment. So I'm asking, what is the difference between these two provisions?
Yeah, Mr. Speaker, I think they carry the same weight.
So which one will you drop?
I think we can drop XII.
So move accordingly for us to.
Mr. Speaker, may I move that amendment proposed under XII be deleted?
Application hereby granted. Now, let's accede to your request to come back to clause.
Speaker, thank you very much. 74.
74 under the new.
Yes.
The winnowing document.
The winnowing document. Speaker, qualification for enrollment. Yesterday, a debate ensued here. The Honorable Attorney General even made a point that you may qualify, you may have passed all the exams, but because you may not be a person of high moral character, you may not be enrolled. And Mr. Speaker, I've looked through the qualifications for enrollment, and that is not present. So I propose that we add that to 2D, so that the new rendition will read after C is of a person of high moral character.
74.
Yes. No, I don't have it. I just want us to add to it. Who has objection? Honorable Baba has objection. Okay. That's.
Yes, Honorable
Mr. Speaker, you see,
Patrick.
we have the legal profession, the professional etiquette rules. That makes provision for what John
He's
is
talking about,
So
yes.
I don't think we have to legislate on it.
No.
That's my objection.
Yes, you are right. You are right. So let's come to the short title.
Speaker, I think that the LI he's talking about is for lawyers. This is for students who are now becoming lawyers.
You see, John Dako, this law is talking about qualification for enrollment, but not the actual enrollment. Not the actual enrollment. It's talking about qualification for enrollment, but the actual enrollment, the regime is out there.
No, Speaker, I see John's point. To be eligible to be sworn in as a lawyer, to be called to the what we call to the bar. Now, no, at that point, there's been some confusion and it's been abused. Even people have gone to court about it, so we've been struggling to define what does high moral character mean. Because you see, so we cannot legislate on it here, you know. So we have moved away from those mechanisms, John, because it's been abused and people have suffered unduly.
So let's just go back, Speaker, in a minute. So, AG, are you resolving from your argument we were making yesterday that you can qualify, but because of because you don't have the character required, the standard required, you will not be called. You made the argument, and I agree with you. So you realize that somebody is a thief just before the person is called. And on what basis would you say that this person will not be called? It's only when you can prove that under the law, you must be a person of high moral character before you be called. Otherwise, that person, there will be no legal basis to deny the person the enrollment.
No, Honorable John Dako, this particular law is dealing with your academic qualification to be called to the bar, to be enrolled. But the actual enrollment has conditions for you to satisfy. So if you don't satisfy those conditions, you can qualify per the courses that you have attained, but you will not be called to the bar. So at this particular level, we should not be legislating those conditions based on which you can be called to the bar. That is not what we are called upon to do. Yes, Dr. Sosu.
Thank you very much, Right Honourable Speaker. Mr. Speaker, I think that I tend to agree with the argument of Chief Whip, because otherwise what you'll be doing is that you are going to prescribe moral standards for being called to the bar. Somebody can get up and say that I suspect this woman is a quote and unquote a prostitute, so they cannot be called to the bar. And I think that would be an affront to the law. When you are practicing and you have issues, disciplinary issues, there is a regime that deals with that. So please, for the students, let's allow them. Let them come and train, and let us get them in. Then we can take it from there. Mr. Speaker, thank you so much for the opportunity.
Yes.
My last point, and I won't talk about this again. No, because, Mr. Speaker, the issue of high moral characters is even in our constitution when it comes to the appointment of Supreme Court judge. Yes, that is where we got the Urban case from. Exactly. So it is important. Our constitution requires that before you become a judge, you must be a person of high moral character. And so you have to start that from the time you are called to the bar. We cannot take this out. Before you are called to the bar, you must be a person of high moral character. Otherwise, you're going to end up with a lot of thieves in our court. I rest my case. After that, we can put the question.
Yes. Attorney General.
Right Honourable Speaker, the example I gave.
Yes. Attorney General.
Right Honourable Speaker, the example I gave yesterday was just to say that the fact that you have passed the law practice course in and of itself is not a basis for saying that you must automatically be enrolled. So there are other criteria that are taken into account. And the honourable member for Okwai Central has just pointed out that we have a legal regime for that already in existence. Mr. Speaker, if you remember the case of is it Ama Governor? Ama Ghana. Yeah, Ama Governor. I said I was right. So if you remember the case of Ama Governor, all right, she passed her exams, excellently. But the General Legal Council took a decision not to call her to the bar, not to enroll her onto the role of lawyers, just because of certain social media, videos that they saw that they thought were below par in terms of moral turpitude, and so they refused to call her to the bar, and she had to, as the Chief Whip has said, she had to go to court to compel the General Legal Council to call her to the bar. So, Mr. Speaker, I don't think that this is something that we have to legislate here, particularly in light of the fact that if we say of high moral character, as it is stated in Article 94 of the Constitution in relation to us, then you might have to necessarily define what you mean. And I don't think that we can legislate that here.
Yes. Chairman of Committee, the short title.
Mr. Speaker, 66. Mr. Speaker, before the short title, may I just take us back to the window document on clause 66, 1B.
Please move the amendment to the short title, then you can take me back.
Very well, very well. Mr. Speaker, amendment proposed XIII, delete reform. Mr. Speaker, reform is very much getting close to reset.
So what will be your new rendition?
So we're deleting reform.
What will be the new rendition?
Mr. Speaker, the new rendition will be
The legal education.
It will be Legal Education Act 2026. I so move, Mr. Speaker.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment to the short title is ordered to stand part of the bill.
Mr. Speaker.
Now, your
I thought I said act. It should be bill.
Yes.
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 So may I say it again, Mr. Speaker?
Very well.
Legal Education Bill 2026. I so move.
Very well. So You said you have concern about some provisions.
Yes, Mr. Speaker. With your indulgence, just taking us back to the WeNote document on 66B. B, it says assign responsibility for invigilating and marking the National Bar examination. May we add scripts to the examination scripts? So, assign responsibility for invigilating and marking the National Bar examination scripts. I so move, Mr. Speaker.
Is the examination in the form of only script? What happened to your advocacy? Is it also a script you are going to mark?
Mr. Speaker, what do we mark? We mark scripts.
Yeah, but if it is online.
Well, it is for the consideration of the House. Yes.
Speaker, Chairman may have to be reminded that in this law, we're making provision for electronic learning, where students may apply AI tools to write their examinations, where that paper scripts may not be available in print for marking. So he may have to avoid getting into that space. In any event, advocacy in that moot assessment, the professor who will be assessing you will be marking you. You will be undertaking an exam, but that exam will not be scripted.
Mr. Speaker, I'm persuaded.
Yes, Majority Leader.
Just to take on board the fact that a script is not necessarily a piece of paper. A script is not necessarily a piece of paper. A script can be on a piece of paper. But electronic online scripts are also there. Electronic online scripts are also there. The platform can be online, the platform can be on a piece of paper. What you have written is the script. What you have written is the script. Pardon? Not necessarily on paper, it can be electronic, it can be on your laptop.
Yes, so
your script is.
Leader, why do we give problem to ourselves when the problem is not there? The rendition is assigned responsibility for invigilating and marking the National Bar examination. So no matter the form of the examination, you are assigned the responsibility of invigilating and marking the exams. That's all. Where from the addition? Long title.
An act to establish the Council for Legal Education and Training to regulate legal education in the country, provide curriculum and standards for legal education, and provide for related matters.
Yes, Chairman of the Committee, any proposed amendment to the long title?
Mr. Speaker, no proposed amendment.
It is for the consideration of the House. In the absence of any proposed amendment to the long title, I'll put a question. As many as are in favor of the long title standing part of the bill, say aye. Those against say no. The ayes have it. The long title is accordingly ordered to stand part of the bill. We have come to the end of a consideration stage of Legal Education Bill 2026. Yes, Majority Leader.
Mr. Speaker, we take the Ghana Investment Promotion Authority bill.
Yes, Minority Leader.
Speaker, just a matter of public interest. Mr. Speaker, I have no objection to the application by the respected leader of the House. But Mr. Speaker, I want to make this inquiry. The Ghana Union of Traders Association has sent a petition. Very well, let me finish. Has sent a petition to the Ministry of Finance on the threshold. I just would want to be sure that the Ministry of Finance, through the Deputy Minister who is here to lead the bill, has actually taken it on board. Mr. Speaker, when we met with them as minority, they expressed serious concerns about their business. And I don't want us to write this bill as if their petition does not exist. So, Honorable Deputy Minister of Finance, respectfully, the GUTA, Ghana Union of Traders Association, sent a petition expressing a serious concern about the proposed threshold. They brought it. They brought a memorandum. So I just want that to be
Minority
clear.
Leader, what will happen is that if you have a copy of that particular petition, when we get to the provision in question, you can use the petition to propose an amendment.
Mr. Speaker, thank you for the education. But I just want to be double sure that the government is a listening government. I just want to be double sure.
Mr. Speaker, I want to assure the
Ghana Investment Promotion Authority bill at consideration.
My humble prayer is for us to take motion number 20 and do third reading of the legal reform bill. Then, legal education bill, yes. Humbly,
well.
Mr. Speaker. And my brother Jerry is not opposed at all.
Okay.
Speaker,
Yes,
I've engaged him.
Minority
He's not
Leader.
opposed. When we engaged, the Honorable Minority Leader was not here.
Yes, Minority Leader.
Mr. Speaker, there is a very good reason for enacting our rules to allow for second consideration and to allow for notice to be given when we doing third reading. Mr. Speaker, I am not saying that an issue regarding this bill may suddenly arise, but it may. Mr. Speaker, I don't want our friends in government to create a certain impression out there that everything must be rushed. Mr. Speaker, we just finished consideration. The rule allows us, at least, for us to come back tomorrow and do third reading. Mr. Speaker, there is no need to rush between now and tomorrow. What is it at all that you think will stop you from having the third reading done tomorrow, that at all costs it has to be done today? Mr. Speaker, we should invoke that exceptional provision, Mr. Speaker, only when it is required. Mr. Speaker, now everything
they would come for waiver, apply for waiver. Mr. Speaker, our friends in government must really come up with a change. Mr. Speaker, if they mean reset, they should properly reset. Every now and then they will say that, oh, it happened yesterday. It is the reason why you say that under this dispensation there's something new. You have not stopped sole sourcing. Now it is clear, everything sole sourcing. Now today we've just finished consideration.
Honorable Minority Leader.
And you now want to do
Honorable
third
Minority
reading
Leader,
now.
with
Mr.
all
Speaker,
due respect,
they
you
should
are
come back tomorrow.
operating out of order.
Mr. Speaker, the minority leader has a motion that he wants us to take tomorrow. We are trying to clear our calendar, to create space so that the motion can be taken. But if he wants us to crowd tomorrow's agenda, if we crowd tomorrow's agenda and it becomes difficult to take your motion, I don't want you to blame anyone. Don't blame me. I said that, don't blame me. I said, don't blame me. We want to clear a lot of issues today. We don't want us tomorrow to come here and be dealing with the legal education bill. So let's just take the third reading. So let us have the abridgment of time so the third reading can be done, so that tomorrow will be free for other equally important motions. I have two motions, Mr. Speaker. I have two motions that are pending. In the order of priority, my motions come before his motion. Mr. Speaker, the learned Attorney General is in this chamber today. So I'm sure some people want to impress him. Mr. Speaker, but if they want to impress him, they should equally inform him of the industry of members who have ensured that this bill has gone through all the stages. Because, Mr. Speaker, even when he was engaged in other mandates, this House continued to consider his bill. So, Mr. Speaker, that is what they want to do for him. I have made my case that you should not do third reading today. If you want to do it, Mr. Speaker, as it pleases them,
Speaker, I am happy the law students are listening to the minority leader.
Motion numbered 19. Attorney General and Minister of Justice.
Right Honorable Speaker, I beg to move that, notwithstanding the provision of Order 172, Sub-Order 1 of the standing orders, which requires that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least one sitting day has elapsed. The motion for the third reading of the Legal Education Bill 2025 may be moved now. I so move.
Honourable members, motion ably moved. Any seconder?
Speaker, I rise to second the motion.
Motion moved and seconded. It is for the consideration of the House. This is a procedural motion. I will therefore put a question. As many as are in favor say aye. Aye. Those against say no. The ayes have it. The motion is adopted. Now, consequential motion numbered 20, Attorney General and Minister for Justice. You have the floor.
Right Honorable Speaker, I beg to move that the Legal Education Reform Bill 2025 be now read the third time. I so move.
Motion ably moved. Any seconder?
Mr. Speaker, I beg to second the motion.
Motion moved and seconded. It is for the consideration of the House. I'll put a question. As many as are in favor of the motion say aye. Aye. Those against say no. Honourable members, the ayes have it. The motion is adopted.
An act to establish the Council for Legal Education and Training to regulate legal education in the country, provide the curriculum and standards for legal education, and provide for related matters.
Honourable members, that the Legal Education Bill 2026 is duly read for the third time and accordingly passed. Yes, Majority Leader.
Mr. Speaker, let me thank colleagues for their industry and the work, the diligent work that they have done to ensure the enactment of this bill. Mr. Speaker, let me also congratulate the Attorney General and Minister for Justice for bringing the bill and successfully shepherding the bill through to the point of enactment. Mr. Speaker, this was a major campaign promise of the National Democratic Congress. And as has been typical of the National Democratic Congress, promises made are delivered. We've made promises and we are delivering on those promises. We promised law students that if they voted for us, we will carry out reforms that will ensure equity, fairness, and access to legal education. We have today successfully passed the bill. We believe that this is the dawn of a new era, where all students will be fairly treated. Whichever law school you go to, whichever law faculty you attend, all of us would end at the doors of the National Bar Examination. All of us, whether you went to Legon, or you went to UDS, or you went to UCC, or you went to Winneba, wherever you went to law school, we will all end at the same place, which is the National Bar Examination. And it is there that lawyers will be determined. This is a promise that the NDC made, and we have kept the promise, and want all to witness that we have kept the promise. Mr. Speaker, let me conclude by once again congratulating the Attorney General and Minister for Justice for bringing the bill expeditiously to this House. But let me thank colleagues also for making time. Sometimes we've sat till very late in the night, and especially our friends on the minority side, some have really shown commitment to the agenda of the National Democratic Congress. I'm surprised that they campaign on different platforms. I'm surprised that they campaign on different platforms. They didn't campaign on this platform. But when the bill came, they were so dedicated and committed. And indeed, some of them made very far-reaching proposals for amendment, which were carried on the floor. So I want to thank them very much. I hope that in the next electioneering campaign, we'll all campaign on the same platform.
Yes, Minority Leader.
Speaker, with respect, let me add my voice to what the Majority Leader has said in part. Mr. Speaker, indeed, the bill was introduced by the learned Attorney General, and the chair of the committee, together with his ranking and members of the committee, through the industry, shepherded the bill and brought him to the House floor after the referral was made to them. All of us have participated. This is not a bill that identified with a particular party. I concede, indeed, that they made it a campaign promise. I concede. And I'm happy that as Leader of the House, he is sharing the success story of his government. what else can a leader say when he has succeeded in making sure a thing like this has happened? Mr. Speaker, however, they equally promised that there will be women banking. Mr. Speaker, that they were going to set up a bank for women. Mr. Speaker, we've done with year 1. Year 2, we have not seen the women bank. 2, Mr. Speaker, they said that when they come into office, they would introduce 24-hour economy, 1 job, 3 shifts. Mr. Speaker, they said that, even if you are weeding at night, they will give you torchlight to weed. Mr. Speaker, again, they said that as for source sourcing, they will never do source sourcing. Mr. Speaker, the president spoke about source sourcing at the manifesto lunch. When he got into this chamber for the sonar, his first sonar, he talked about no source sourcing. The second sonar, some few weeks ago, he again said no source sourcing. The majority leader himself, at the dispatch box, when he was closing the debate on the sonar, re-echoed no source sourcing. But today, we know that they are the apostles of source sourcing. Mr. Speaker, they also said that in their government there will be no family and friends. They said there will be no nepotism. Mr. Speaker, they said that contract will be open. Today we know that at the presidency, the deputy chief of staff has been awarded a so-so contract, 11 million by Gold Board. This they said they won't do. Mr. Speaker, so I'm reminding them that the very things they said they won't do, they are doing. Mr. Speaker, they say cocoa, they would increase it to 6,000 per bag. Today they have reduced it to 2,500. So, Mr. Speaker, I am happy that the majority leader is saying that out of 10, they have only 1 success. Mr. Speaker, out of 10, they have only 1 success. Today they have performed.
Mr. Speaker, you are asked to correct the record. He didn't say so.
Mr. Speaker, very well. Mr. Speaker, out of the many promises they made in their manifesto, just 1. Today, just 1. Mr. Speaker, the value for money bill, Mr. Speaker, if you look at the governing board, that defeats the whole purpose of the bill, where politically exposed persons are being loaded. Mr. Speaker, that law lacks independence, and the finance minister who introduced the bill could not justify the other jurisdictional, Mr. Speaker, the other jurisdictional interests that they were introducing to help. Mr. Speaker, he said in Canada they had value for money. He said in the UK. But before this house, the finance minister could not bring one law to support, and they have passed a politically exposed law which would not solve the very problem they seek to cure. Mr. Speaker, I will not belabor ab initio. The mighty minority told the people of Ghana that with time they will see the true colors of the NDC.
Ghanaians have seen the true colors of the NDC. And I'm sure, just as that poor cocoa farmer said, Mahama, what the in other words, they are saying that the president owes them for their cocoa. He has to pay. No matter what he does, he owes them. Mr. Speaker, I won't belabor. I want to join the majority leader in thanking the members of the committee as well as the backbench. Mr. Speaker, I came here in 2013 and it was difficult to see my way through. I have seen the industry of many backbenchers and it's very impressive. Both sides, Mr. Speaker, you see backbenchers participating in lawmaking, their debate on the floor, the quality of debate. Mr. Speaker, this parliament has a future. So what is important is for the whips, particularly the chief whip on the majority side, to encourage the backbenchers to do more work. Mr. Speaker, the backbenchers are saying, what do you Mr. Speaker, I rest my case.